So I want to say a few words about Roe v. Wade. Many people, of course, think that Roe v. Wade is a Pandora's box of controversy, which it is. I encourage you to read Roe no matter what side you're on, especially if you have a side that you're on. If you're pro-choice, you should read Roe to find out what its vulnerabilities are. If you're pro-life, you should read Roe also to find out what its vulnerabilities are. Everybody should understand the basis on which it was decided. The story is this: a pregnant single woman named Norma McCorvey brought a suit against the Texas criminal abortion laws because abortion was outlawed in Texas except if the mother's life was in danger. So several people wanted to join this. One was a licensed physician who had some charges against him because he gave people abortion advice. And another was a childless married couple who the wife had been advised by her doctor not to get pregnant, and the couple, for her health, and so for that and for personal reasons, they decided not to have children, but they felt that if she did accidentally become pregnant, it would be a hardship to them and dangerous for her if they couldn't get an abortion. So here's the reason why I bring this up. It may seem like a minor thing. Basically, the court said that Roe had standing and that the physician had standing, but that this childless couple did not have standing. The argument was that it was a speculative situation. They hadn't experienced harm. Just the fact that they could experience harm in the future wasn't enough to give them standing or interest in the case. So I only point this out because this issue of standing is an important one for the courts to decide. So they decided that they couldn't join the case, but that Roe and the doctor could. So another thing that was important that was decided is because she was pregnant at the time, obviously the time it takes for a case to go through the courts, the pregnancy, I think she had the baby, and it was given up for adoption. Anyway, the pregnancy ended. And so the objection, of course, from the other side was that she no longer had standing to bring this case because she was no longer pregnant. And the court said, I think quite rightly, that basically because pregnancy is of a short term, if you rule that no person who was pregnant, who isn't anymore, has standing, then you basically said no pregnant person is ever going to get a case heard in the courts, and that doesn't seem right. So that happened. Okay. So Justice Blackmun delivered the opinion of the court, and he said a couple really important things that I just want to point out to you. He pointed out that it was an incredibly sensitive issue. He pointed out that he talked about who these people were. Let's see. He's talking about interest in the outcome, which is the standing question. He decided to talk about attitudes, because one of the things that the courts always decide is what's the tradition or what's the sort of popular opinion about this issue. And he, even though some people are very anti-abortion, the history of abortion is not one of criminality or intolerance. What he said is ancient people practice abortion. Greek times, Roman times, it's in the Bible, it's clear throughout history that it's been a practice. Greek and Roman law did not protect the unborn. The Hippocratic Oath is another sort of custom that they looked at. The Hippocratic Oath, of course, is where doctors pledge to, not do no harm, basically. And the court decided that this did not this wasn't enough to say that the medical profession had been against abortion. They didn't consider embryos people, so that wasn't proof. The Hippocratic Oath wasn't proof of any ancient attitude that was either pro or anti-abortion. They looked at the common law and found that there was a custom of quickening. The idea in the common law is that once babies start to move around or quicken, they are living beings and should be protected and seen as potential living beings. So the idea of quickening was when babies were considered to be on their way to being people. So that was one. Before quickening, not so much. So the judge took that sort of into consideration, that quickening is a kind of received common law idea of when life begins, basically. They look at felony law and go through a lot of that. You're welcome to look at the different examples of basically defining when life begins, which, as you know, we have not settled yet.